23rd of September. Stone Dim, you also in this one?
Yes.
Another one, okay? So 23rd for the mission. Okay, good. Okay, very well. Yes. Pre-trial. Okay, very well. Okay, very well. Now, Council Okuta, because that is a value you need us to address for today. I think that today we can only do that. Then what we'll do, David, we'll dispense with your attendances when it comes to the hearing. You will be coming 14 days, correct? But the dates for pretrial you must be. You can apply for the release of the cell. Is that okay? So, Council Kuta, Orasala and Mare, the projection on the exchange of the documents. Mr. Kuta, it's okay. So we have set the test sheets and the statements. So put you know, you hit the contact list. So you reach out to each other, then you can agree on when. Thank you. We can release you for today. Yes, Council Kugat. Good morning to you, Council.
Kibala for the prosecution. Sorry,
consider that particular probation report. Then later by Council Hillary Keeper on one of the issues that I was to determine whether Mr. Devani can answer the judges on behalf of Triton Petroleum Limited. I've also addressed that. And Council Kiplanga can confirm that he also wrote that particular letter. We are also aware of the lead counsel. Then I also saw Mr. Devani's lengthy affidavit with the settlement agreement. Correct? There's a bit, I may not fully address myself with the settlement agreement because of the stage of the proceeding that we are in, and that may be, I think it may be a matter of interest that the full trial you'll be able to deal with, correct? Yes, but it is good. He also brought it forth with the things also good. For the prosecution, I also got your submissions on the question of the company. You filed a report from the registrar of companies from the business registration about Triton company, which I hope you also have learned and also your list of approaches. So all those particular approaches in which time one has been able to use them and they have enriched the decision that for this court, charged with 11 counts of fraudulent distribution of mortgages. Of course, clearance to defraud and obtaining money by force practice. All between September 2008 and December 2008. On 7th August 2024, the first accused person proceeded to plead not guilty to the charges. However, Mr. Kurgat, leading Mr. Kiplanga, Mr. Mpaka, and Mr. Chesa, who are advocates on record for Mr. Devani, objected to have him answer the plea on behalf of Triton Petroleum Company Limited. In brief, it is the contention by learned counsel to record for Mr. Devani that the company is currently under receivership, although no details were supplied then. In a turn of events, Mr. Kiplanga, instructed by H&K Law Advocates by a letter dated 15th of August 2024, referred to the court's directions which are issued on the 8th of August 2024 and intimated that the objection was abandoned, so that deals with the issue of the letter by Council Kiplanga. Needless to note that ESCC, by an affidavit that was deponed by Andrew Leka Parish on 15th of August 2024. And annexed a letter by the Assistant Registrar of Companies dated 15th of August 2024 with details about Triton Petroleum Company Limited, now in receivership. No doubt, Mr. Devani, you are the majority shareholder of this private company since its registration on that 1st of July 2024 until 19th of December 2008. When the initial receivers, that Mr. Abdul Zahir Sheikh and Peter Kai, were appointed as joint receivers by the Eastern African Trade and Development Bank, PTA Bank. It is therefore imperative that Mr. Devani is the fit and proper person to answer the charges against the company for any acts committed prior to the receivership. This position is guided by the statutory provisions and Section 23 of the Penal Code on offences against juristic persons, and as was rightly submitted by the prosecution. That's the letter submission which comes over Walusala and your colleagues you filed. So now that one deals with the first limb of the ruling that I was to deliver. Second limb of this ruling is with regard to the release of the first accused person on bail. Prosecution strenuously opposed the release of the accused on bail, citing compelling reason that is a flight risk. Mr. Walusala and the prosecution counsel object to the release of Mr. Devani on bail and argued that is a flight risk. The prosecution placed reliance on the affidavit opposing bail, deponed by Andrew Leka Parish and an investigator working at ESCC. The affidavit was sworn on the 6th of August 2024. The investigator averred that Mr. Devani was supposed to be arraigned in court together with other suspects on the 16th of June 2009 in anti-corruption case number ACC number 18 of 2009, but fled to the UK to avoid trial. It was also said that ESCC in August 2009 obtained a warrant of arrest against Mr. Devani, in this case ACC number 18 of 2009, the one that will be the due. They added that ESCC, in collaboration with the Director of Criminal Investigations, that's ECI, and the Director of Public Prosecution, the DPP, initiated extradition proceeding in the UK against Mr. Devani. The extradition proceedings were the subject matter in the decision Court of Appeal, Civil Division, Secretary of State for Home Department versus Yagnesh Devani, 2020, reported in EWCA, Civil 612. That's a citation of the English court, where the order to extradite first accused person to face trial in Kenya was granted on the 7th of May 2020. According to the investigator, Mr. Devani was extradited from UK to Kenya on 23rd of January 2024 and charged in Milimani CMCR case number E072 of 2024, Yagnesh, Mohana, Devani, and another. In the end, there you are about that Mr. Devani has demonstrated that is a serious fresh risk and aids the objection to release him on bond. First accused person in reply to the prosecution objection, you filed an affidavit on the 12th of August 2024. That's the affidavit Sakugat you're inquiring about. And the key highlight of the averments was that on the 16th of March 2009, Mr. Devani executed a deed of settlement with ESCC at Dubai. By that instrument, Mr. Devani surrendered assets owned by his other companies to settle debts obligation not to the Triton Petroleum Company Limited financials. He complained that in spite of executing the deed of settlement in good faith, the instrument was reneged and he was charged in 4 criminal cases, including the present case. Additionally, Mr. Devani averred that due to the hyper-political and sensationalized, the way the man was sensationalized, the cases were handled, and the manner in which the case was being handled and the reneging of the deed of settlement, he then opted to fight the extradition to Kenya through proceeding the UK courts. It is positioned that he was lawfully in the United Kingdom, having secured his stay by lawful orders of the English courts until January 2024. He went through the various English courts, from the lower court to the high court to the appellate court. Mr. Devani further averred that after the conclusion of the extradition proceedings, he did not flee United Kingdom during the 1 month notice that was granted by the courts, and that he cooperated with the officers from the DCI when he was being brought back to Kenya in enforcement of the warrant of arrest issued in the criminal cases. He averred that in Milimani CMCR, case number E072 of 2024, the prosecution did not oppose his release on bail and was granted a cash bail of 1 million. Mr. Devani also averred that he was a citizen and a resident of Kenya. He stated that he was living with his wife and an adult son, and lastly, he urged this court to release him on favorable bond terms. Having considered the affidavits filed by the investigator and Mr. Devani, that's beside the rival submission of the parties. The main issue for determination is whether Mr. Devani is a flight risk. That's the main contention. This is the court determination on the question. The release on bail is provided under Article 49(1)(h) of the Constitution, as well as Section 123 and 123A of the Criminal Procedure Code. I won't read the provision because 49(1)(h) and 123 laid them out on the ruling. It is trade law that the primary consideration in the exercise of court jurisdiction in bail decision making is whether the accused person will turn up for the trial. Bearing in mind this primary factor, it is the duty of the court to demonstrate the courts, and on a balance of probabilities, the existence of any potential reason has justified the definition is not a matter of any reason, it is a matter that has been developed through judicial. I'll pick the very initial Abolafadi, Mohammed, and another at 2013, where the accused person, a foreign national, the Iraqi case, was facing terrorism charges. And it was found to be a flight risk. In that particular decision, flight risk was then considered to be a compelling reason to deny release on bail. In the bail and bond policy guidelines, as revised, paragraph 4.9(1), accused person is a flight risk on the following grounds: where the accused is a foreigner who does not have a fixed abode or hosts in the country, and Kenya does not have an extradition treaty with the accused person's country, or foreigner where there are no extradition treaty, because there is a presumption that he or she is a flight risk, and therefore there is a very. And the court goes to explain the rationale for this. Bail upon such a in the instant case, this explanation is valid in the terms of this case, and to distinguish the facts in the case that was cited by the prosecution of Republic versus number 81 135 Kopro Kipkurui Selote at 2020 KEHC 1314. The relevant fact in Selote case was that accused person, a murder suspect, it failed to honor summons to attend court. And secondly, which I think was a major factor for the court to, at that point, to deny him bond before the key witness had testified, is that he was likely to interfere with the key prosecution witnesses who are known to him. That was a major factor and distinguishes this particular case. Another key consideration by the court in the release of Mr. Devani on bail without the prosecution objection, another key consideration by the court, which I find very key, is the release of Mr. Devani on bail without the prosecution objecting Milimani CMCR case number E072 of 2024, Yagnesh, Mohanla, Devani, and another. This court must contend with the decision, that's very important, to deny the release of the accused person on bail when he has been enjoying the right to bail in a similar case. That's a matter that this court has to give a very deep thought. It is my considered opinion that a variance in the manner the courts will treat the same person in two cases on the aspect of the right to be released on bail will not be in the best interest of justice. At most, a uniform approach will be appropriate, except for terms and conditions. That's my take. This court then called for a prepared report of Mr. Devani. The report was done by Sally Wanabisi, a probation officer at Devani, and was filed on 15th of August 2024. According to the information contained in the report, the accused was confirmed to be a Kenyan citizen residing at Westlands in Nairobi with his wife, Sonal Devani, and her son, one Aryan Devani. He also has a nephew, K.U. Rajan. I'm not very sure about my pronunciation of your names, but you bear with me. He's also said to have strong community ties, and he stated that accused person is at present running a company by the name Lord Group with office at the Chancery along Valley Road. The accused has expressed willingness to deposit his passport in court pending the trial determination of this case, and in addition, accused person's son and nephew have affirmed the intention to stand surety for him. Those were matters that arose from Sally Wanabisi report. But I note from that report there was a problem on the date. The date is written as 19th of August. We'll check on it. But I think let's deal with substance and avoid the technicality. From this pre-bail report, Mr. Devani is recommended for release on bail. On careful evaluation of all the materials placed before me, I do not find evidence that Mr. Devani is a flight risk. And I've given the reasons. The asylum and the extradition process and the UK sufficiently explains your absence from Kenya. Considering the prosecution conduct in Milimani CMCR case number E072 of 2024, I find that it is inappropriate to deny the accused person release on bail when he is enjoying the right to bail with the full knowledge of the prosecution, that other matter. I therefore dismiss the objection and note that first accused person, you are entitled to be released on bail. The criteria to determine the bail terms was aptly considered in the decision of Edel Sum versus Republic at 2022, EKLR, quoted with approval in the case of Mohammed Chute, Wote, and two others versus the Republic at 2021, EKLR. In that decision, it was held that the court, in reviewing the bond granted by the trial court, it's essential that the court succinctly brings out purpose of bail and bonds. In Mohammed Chute, Wote, and two others, was the Republic at 2021, EKLR. The learned judge, Grace Yoka, expressed herself on the article 49(1)H, section 123 of the CPC, where she had as follows: the keyword is reasonable. Thus, the question that arises, what criteria should be used in determining what is reasonable? In my considered opinion, the starting point is the recognition of the fact that under Article 52 of the Constitution of Kenya, every accused person is presumed innocent until proved guilty. The purpose of bail and bond term is to ensure, therefore, that that's the primary consideration. Further, provision of Section 123R of the CPC provide the relevant counts to be considered, including nature, seriousness of the offense, character of the accused, record of compliance with previous bail and bond terms, and strength of evidence to be adduced. The grant of bail, court and end of court. The grant of bail, although an exercise of discretion, this court shall be guided by the foregoing authorities, or those authorities have stated. I'll also be guided by the bail and bond policy guidelines. I've also looked at the nature of the charges, and I've also considered the social inquiry in respect of accused person as borne out by the pre-bail reports. In the upshots, I noted that one, accused person, that's Mr. Devani, you shall forthwith proceed to answer the charge on behalf of Petroleum Company Limited, and thereafter you shall, and then you shall also be released on the following bail terms. One, accused person, on your behalf and on behalf of the company, Petroleum Company Limited, you shall be released on bond of Kenya shillings 20 million with one short for similar amounts. That's if it is a property, 1 million, one short for similar amount. Or in the alternative, a cash bail of 5 million with two personal sureties for Kenya shilling 5 million each. Mr. Kurugat, I'm a bit tough on that one. So, in the pre-bail report, there are those gentlemen. I'll be very much interested if we can retain the same people who they have identified themselves in the pre-bail report to stand as the personal sureties for Mr. Devani. So long as you are attending court, there is no problem. So if you want to do property, do property. We will not require personal sureties. But if you are depositing cash bail, you deposit 5 million, then we shall examine those two people. They will not bring their property, but shall examine it to check their particulars. And in the event that you are not attending court, then we shall deal with them under the law, as well as follow the procedure of 5 million. Is that one understood? And I've said I really want the son and the nephew who knows it very well. Those are the people that I'd be very much interested. So then the second condition is that Mr. Devani, you are barred from traveling out of the country. I know you are a businessman. Please, you should not leave the jurisdiction of the country without leave of the court. If you want to travel, come and inform the court. You look at your trial arrangement, then they'll tell you. And for that, you shall then have to bring your passport so that we deposit it with the courts. Number 3, accused person is also barred from contacting or interfering with the prosecution witnesses. You keep away from the prosecution witnesses. Then we shall agree on the date for the mention for the trial when conference after exchange of documents. So I think that brings us to the end of the ruling. In case there is any clarification from the prosecution, I can take any question on any clarifications. Mr. Olasal?
We've appreciated the conditions we've imposed. This court is clothed with the power to review the bond terms that terms that are granted in the circumstances.
Yes.
I think we would not be out of order if we were to request that having considered and also requesting that we reconsider again the probation report and reduce the cash bail of 5 million because it is high given the circumstances. Our client is a Kenyan citizen and courts in this country, especially the High Court, have said that once the court has given the bail, it become fund to sufficient. So our request is in that 5 million then still amounts to nearly denying him the liberty that he's entitled to in law under Article 50, sub-2 Constitution.
Okay, would I,
Yes.
let me indicate, I think I'm telling you from where I go.
Yes.
It's my own practice. Yes. I won't deliver what up now. Yes. Then I review them.
Okay.
But I do review. Like the case that you have made for David.
Yes.
Correct? I did review. Correct? I did review for it. But you must demonstrate it. Correct? Because for me to review, I have not really paid it on the figures in the chart sheet. Correct? Neither have I just plucked them from anywhere. But I've also looked at another comparative matter of equal weight. So what happens is this. You don't even need to argue that you can't raise it. I agree. I'll be the first one to agree.
It's all right. We are looking at the possibility.
Yeah. Look at that possibility.
Now that you've expressed.
But meanwhile,
now that you've expressed it.
Also,
yes.
Also, if you are ready for your cash bail, do it immediately. Then come for the gentleman who are the personal surety. They come and deal with that. You have no problem with that. Is that okay, Councillor Walusa?
Yes.
Is that okay?
No, you. It's all right.
So
let's just go by what you said.
Yes.